Our third speaker is Dr. Niva Elkin Koren from the Law Faculty of the University of Haifa. I don't think that I will exaggerate if I say that Niva is the leading intellectual property scholar in Israel. She wrote numerous articles in intellectual property, and her recent publication is a book on law economics and cyberspace, which was written with a colleague of hers in the Faculty of Law. Niva, please.
Thank you, dear co-author. Okay. So we heard about the value of sharing and having a public domain, I guess, and Hagit stopped at a point that is a bit skeptical of the way of changing it. Like, we have to accept the reality of turning science into a commercial good, and we'll just have to learn to live with it. And one of the questions that I would like to address is the alternatives for cultivating the public domain, not necessarily in science. We'll talk about that hopefully at the end. We also heard that, yesterday at least, that the information economy in which we live is putting pressure on governments to harmonize their domestic laws, and not only to harmonize them, but also to make the intellectual property laws and intellectual property rights more expensive. I guess we all agree, Professor Marty Edelman as an exception, that intellectual property rights expanded over the past decade. We offer more protection to more works. Stem cells and data are examples. We offer it for a longer duration. We offer more robust rights, such as data exclusivity that we discussed this morning, and digital right management that hopefully will be discussed in the afternoon session. And extending the intellectual property regime definitely has a price, one of which is the shrinking of the public domain, on which Professor Dreyfus just talked. And I want to focus on several aspects of this process, such as that, as was actually mentioned, stronger protection in copyright and patents are creating barriers on access. But also, stronger intellectual property rights make it more difficult for us to share, not only in the scientific context, but also in other contexts, even as a teacher here, right, as a law professor, which I do a lot this semester. If I'm creating a compilation of materials for my students, that's a creative work that would be expensive to put together. It would require me to receive licenses from various authors of different works, to identify the authors. That's a costly process, and I'll have to do it unless it is considered fair use, which I'm not sure it is in Israel. Problems actually increase if I want to make this work available to others. I already created the course and I'd like to make it available to others. That would, the copyright regime as we know it today would make it very difficult and very expensive to do that. It turns out, however, that many of us create works. We take photos, we take pictures, we create music, we write, we teach, we create news reports. We want to share it. We want other people to respond to it. Since copyright law became the default rule, it makes it very difficult for us to do just that. And in fact, the ability or the possibilities of the comeback of individual creators in the information environment that make it very easy for all of us to share our creation is actually hindered by copyright law. Now back to the new IP order that we all learned about yesterday. We talked about the harmonization and the pressure that is put on governments to establish more protectionist regime. And now the question is actually how are we going to cope with it? How can we secure a public domain regime in global intellectual property regime? And one option is private ordering, and that's the option I'd like to discuss. And this is an option that was already made possible by the licensing platform designed by the Freedom of Software Foundation, which is governing the open source software, the GPL. And this platform was actually adopted by the Creative Commons, which is a project that defines its purpose as making it easier for individual creators to license their works under more generous terms. And it does it by creating a licensing platform that would reduce the transaction cost of both the creators that are trying to put the works out there subject to certain terms and don't want to pay the legal fees to any lawyer, and also to users that are seeking creative works and want to reuse them some way or another. Now, this licensing platform would allow creators to license their works under various contracts according to their preference, which would be a combination or any combination of the following options. One would be attribution, meaning that you're licensing your work subject to the duty of the user to give you credit. Non-commercial would perhaps prohibit any commercial use of the work, but would authorize every other use of the work. No derivative work would license the work as is and would prohibit any unlicensed creation of a work that is based on your work. And the last option is particularly interesting, the share-alike option, which allows the creator the author, to release the work subject to a license that would go with the work, a viral license that is actually seeking to impose the same terms and conditions on every subsequent user of that work. Now, another interesting aspect of this project is that a license is released in 3 formats. One is the legal format that would make it enforceable. The other 2 are particularly interesting. The human readable language that would make it accessible to everyone, and the machine readable format that would allow the license to be trackable by the various search engines. Now, Creative Commons, I would argue, should be viewed as a social movement. It is actually a fascinating social movement, especially for us lawyers, especially in terms of law and society. It does not actually advocate a legal reform. It advocates a social change. In fact, it is a reactionary movement in the sense that it preserves the current regime. It advocates the principles, the old principles of the copyright regime. It does not seek a change in courts. It doesn't ask the legislators to change the law. It is seeking a change in legal reality by changing the social norms. social perceptions regarding the individual creator, social perceptions regarding the creation process as something that is interactive and communal and is based on sharing rather than an exclusion. And finally, it does not encourage the waiver of rights, but it does encourage a specific use or exercising rights. Now, what I'd like to point out are two sets of problems that are related to this project. One has to do with the fact that it does not create a public domain, although it seeks to cultivate the public domain. It actually relies on the proprietary regime, and this has strong advantages. One is that it allows the licensors to prevent capture, to prevent the taking of the work by commercial parties, for instance, and locking it in another work, not allowing the public to access it on the same terms. It is also allowing the prevention of abuse, namely that someone else would come and take the work I contributed for free use and would make money out of it. This is particularly important because one of the keys to projects like this is motivation. And if people feel that their work is being abused by others, that could be detrimental to a project like this. It also has some serious disadvantages. One issue actually relates to the to questions Professor Halbert discussed yesterday, which is the struggle over meaning. Since the Creative Commons is really relying on the copyright regime, it is actually reinforcing this regime. It's reinforcing it because it has to be maintained, but it's also reinforcing it by communicating the message that information is exclusive, that information and that a license is necessary for every use of information, and that sharing, which is so essential for the creative process, is prohibited. This is critical, especially in the context of intellectual property law that depend on compliance and internalizing these concepts, these meanings, because intellectual property law is dealing with works that are virtual and have no physical boundaries. Another set of issues has to do with the limits of contract law. One has to do with the enforceability versus third parties. In order, we discussed contract law yesterday morning in the morning session, and as you may recall, a contract is only applied to its parties. If we want to allow enforceability against third party, we actually must relax some of the requirements of assent, of offer and acceptance. We must be willing to live with some very low level of assent, of acceptance, and say, well, behavior, the actual use would be considered acceptance. And that could work, that could serve definitely the Creative Commons, but could also serve the more protectionist use of licensing. A month ago we had a conference here on intellectual property and competition. And in that conference I was discussing the problem of restrictive terms, the way in which these licensing regimes are being used in order to limit discussion of works, limit criticism of work, limit reverse engineering of works. If the contracts are enforceable, then enforceable and could serve both sides. Another problem is the transaction costs. Contracts are based on freedom of contract, and we already see a proliferation of contracts. There are many options, and So now, our purpose was to reduce transaction costs, and because we facilitated this process of licensing. But on the other hand, since there is a variety of contracts, people still have to study them, engage in researching the differences between contracts in order to choose the best contract that fits their purpose. And there is also the problem of compatibility. Sometimes you want to use one work and subject it to and reuse the work with another work. Each work would be subject to different licenses. That could create a problem of compatibility, some of which is experienced also in the open source environment. The last point I wanted to point out in the set of contract issues has to do with the stability, the sustainability of this regime. And just to give one example, what if someone revokes? Creative Commons, for instance, offer an option to dedicate your work to the public domain or make it protected only for 14 or 28 years. What if a person decides that they want to change their mind under the the proprietary legal regime? It's still there. They can breach a contract, but the property rights are there. They could be reliant, and that could also create some problems. So the question is really whether sharing and reuse could be facilitated without the public domain. And of course, the open source is a good example, but the question is whether we can implement the same principles outside the open source to creative content and to scientific works. And I guess I'd just like to list a few considerations. I think that this depends on the type of project. I think Linux, for instance, was a more concrete project. It makes it easier to induce motivation of the participants in such a concrete project. It could be similar in scientific work. Science could be perceived as one pursuit of all scientists. I think it could be more difficult when we think about contributing to what? Culture, civilization. I think the more abstract it is, the less it is likely to maintain the motivation of the community. The established norms in the community are another factor that might predict the success of such project. I guess the more established the norms in that community, the less we're likely to see breach or defection from or abuse of the system, and the less we will need to rely on legal enforcement. The last issue is the type of content and the amount of resources that is needed. Maybe there is a difference between programming and biotech research that we have to take into account. Having said all that, we are launching Creative Commons in Israel. The Center for Law and Technology here in Haifa will be the branch for the Creative Commons. A draft in Hebrew was already created by Ohad Maiblum, that is an attorney that is now completing his master's degree at Stanford Law School. It will be posted online, and we invite you all to participate in the form that we are launching in this email address that is also appears in the materials that we distribute, or there could be picked up outside. And so if we don't get a chance to discuss it over the Q&As, we're looking forward to a discussion online. Thank you.
Thank you very much, Niva. We have some time for questions. Maybe I'll take the prerogative of the chair. The first question, which actually connects the presentation of the three of you, focusing really on research that comes out from university, which is in a sense is already now a sort of a Creative Commons, and my question is whether it's justified to have intellectual property rights at all in university research results and not transfer it to the public domain. if one really accepts the general framework of justification for intellectual property, all its types, for incentives or as a reply to a market failure, actually the remedy for the market failure in the research institutions which pay their scientists salaries which are independent from their discoveries is a remedy for this market failure. Why do we have to have intellectual property at all in the first place granted to results of university research? Maybe the remedy is not Creative Commons but really go directly to the public domain. I would be happy to hear the opinions of the three of you.
And the reason for the Bayh-Dole Act, the stated reason for the Bayh-Dole Act was that inventing things doesn't actually bring them to the public. Inventing things is really the first step. Bringing them to the public requires a lot of other investments. And the perception was that there were not enough inventions being commercialized, being brought to a point where people actually could enjoy their fruits, and then having patent protection would do that. Now, there are certain kinds of inventions for which that's clearly true, and I think the pharmaceutical ones that have been the focus of a lot of our discussion are like that. Whether all things that are invented in universities require that same kind of treatment, that's another issue. And one thing that you might think of doing is dividing up inventions and thinking about certain ones that should be treated differently from others. Now, of course, that runs into the technological neutrality provision in the TRIPS agreement, and that's why our paper is about that, because we're worried that some of these government interventions might be blocked by TRIPS. But as a matter of theory, that might be one way to handle it, to take inventions that can be easily commercialized and put them into the public domain, and maybe create a different kind of rule for ones that do need more investment before the public could enjoy them.
I don't have much to add, but I think in my presentation I emphasized that from the university point of view, there is a real need for extra resources to enable doing the academic research that we are looking at. And this is one way that can be done. Actually, yesterday I attended another conferences where one said there that 70% of their patents are not using for commercialization, but to intrigue ongoing research based on this patent, where the new intellectual property which is created under the new project based on this patent is going to be better than the spin-off from university. Anyway, as I said, I'm not sure if it is a fair question to ask if it is right or wrong. Theoretically speaking, if public money is given to a university to run out the research, then there's no problem. Then take the results and do whatever we want to use it, society. But since this is not the case, we need to look for resources.
Yeah, I guess one problem is that universities are poor, and the governments are poor, so universities are poor. I think that Professor Dreyfus mentioned when we talked during the break that some of the most important innovations came actually from public funding, the defense funding actually. And it means that public funding for substantial research could be efficient. And I think that one of the questions is not only a question of whether it is justified to, whether it is necessary to allow intellectual property in academic research results, but also what price are we paying. And it's not just the price of innovation, but also the commercialization of academic research is corrupting the research. It's, and in the sense that it makes it more biased, it's more focused on creating goods. I think that this was not mentioned in the morning session, but I think it's also related to what else, but data exclusivity. I think that one of the problems is that a lot of research that is being sponsored by corporations is sponsored under the provision that it would not be published. And some of the research, the key research on drugs, for instance, is not being released to the public, and that should be, some of it is considered academic research, and I think that what we're risking here is the trust of the public in academic code. So there is also a loss, not just the.
So you actually give an additional reason why IP should not be given to research institution, because that prevents them from doing basic science and channels them to do more kind of applied science, while we want them to do basic science. Okay, other questions from the floor? Amit. Come to the...
I'd like just to add to your question and ask a second question. I think that you can't ignore the fact that even after you have basic science with astonishing results, you have a long corridor. Take pharmaceuticals, for instance. A scientist came up with a cure for cancer. Between his laboratory, his attic, where he found the cure, and the commercial drug, you have a huge corridor, and you need a lot of funding. And in our political economy situation, without intellectual property rights for those results, nobody is going to invest in the corridor. He has to deal with bureaucrats in health ministries. He has to deal with lawyers that will market the drug. I don't think that without intellectual property rights at the end, it does serve a challenge, and here I agree totally with Niva. The universities have to be a lot stronger. It poses institutional and organizational challenges, and I think Israeli universities are currently trying to cope with that. I don't know, some are more successful, others less, but I don't think you can abolish intellectual property rights in universities, because that way you make them irrelevant to the research that is going on in the market. What I'd like to ask both Niva and the distinguished speaker from is about the challenge of changing trips on another political economic scale. I mean, is it possible at all to have any international framework which would allow for public domain, for more public domain related agenda? The only initiative I've seen in the last year was in the forum that is known as the World WSIS, which is going on under the auspices of the ITU. This is something that talks about using the Information Society Summit. And there were two trends, one led by UNESCO for opening the public domain, another led by WIPO to close the public domain. And eventually the debate went on to talk about the rights of less developed countries and went far away. Do you see any chance, because Israel is a small country, would like to enact more public domain related laws, for instance, but we're enclosed by international norms? Thank you.
We had a wonderful presentation yesterday on the politics of all of this, and I think politics is creating more of a interest in the public domain, and how that's going to play out in TRIPS is a really interesting question. One idea is to have some kind of protection for the public domain. Another idea is, why is TRIPS just minimum standards? Why doesn't TRIPS include maximum standards? Why is it that you can challenge something because it's not offering enough protection? Why can't you also challenge something as too much protection? Maybe like plus 70, 90 years of copyright ought to be regarded as too much protection on a worldwide basis because it's just too long. And maybe TRIPS sort of codify some of that. Now, national laws do have some notions of what's too long. She's a great example. But there are notions embedded in national laws, some of it in antitrust law, and the GATT doesn't include an antitrust provision. Maybe you need an antitrust part of the GATT, regulated aspects of antitrust law, TRIA or something. But maybe that would do something to tamp down on the abuse of the patent system. But putting some of the balance that I talked about into TRIPS itself by creating user rights that would be a good thing. I mean, I think when trips, the last 10 years has really seen a dramatic shift in a lot of different ways. One of them is simply the understanding that intellectual property rights are out there. 10 years ago, people just didn't even know there was such a thing. Now they do. They know it partly because of people like Larry Lessig, people like the anti-globalization people, people like Yochai, trying to wake them up, who really have made a huge effort to make more salient what the trade-offs are. And partly they've actually learned about it from the RIAA and other groups that are trying to tamp down on your ability to get music off the internet. So in some ways the RIAA has done a tremendous benefit to the public domain people because it's made people realize there are serious stakes at issue here. So the original TRIPS agreement gets negotiated against a background in which even a lot of intellectual property people barely knew what was going on. The next round is going to be different. How that's going to actually play out on the agreement is interesting to see.
Just to add on that, I think that if governments are captured, by the corporate interests and are subject to the international regime that is not very supportive of the public domain. The alternative could be civil society, just people communicating through the net. And Creative Commons is one example, but there are many other examples of all sorts of collaborations within universities, seeking to avoid the proprietary system and creating a commons of their own. It's not perfect. I think the real challenge for us lawyers is to think what would be the best legal regime that would support this type of initiatives. And I think that, for instance, differentiation in contract law between an abuse of copyright, for instance, or extension of copyright, or release to the public domain could be something that maybe should be developed in our doctrines.
Microphone, please.
A short comment on the Creative Commons. I asked myself whether the PROs will agree to the scientists and the scholars establishing such a mechanism voluntarily, because it's a question who owns initially the IP that the scientists and the scholars produce.
Well, there are some, not the Creative Commons itself did not develop the scientific model yet, but there are some open source models in biotechnology, for instance. It's a very interesting to look into. So some of them are working.
I'm not saying that it's not possible or that it would not work. That's another issue. I'm saying that the university has also a stake in it. It is not prima facie clear that the scholar owns the IP in his writings and scientific discoveries. But the question to Professor Dreyfus is whether you can offer some explanation as to why in the US the defense in patent law of fair use or experimental use, as we call it, in the US you refer to something else as the experimental use, but so I would use the fair use defense in patent law. Why is it that it is non-existent practically, unlike most or many other countries in the world, including Europe and Israel? Because it is clear that commercializing science and research poses a threat to academic research, and this defense would have been apt to.
The Federal Circuit, which is our court that does most patent cases, has taken the position that if universities want to play in the patenting game, that is, if they want to become patentees themselves, then they are exposed to all of the rules that patentees have. Back in the days when universities didn't get very many patents, I think there was a certain tolerance of university employees utilizing patents with patent inventions without permission and without paying royalties, and that was sort of fine at the time that universities weren't getting patents themselves. And in fact, there is kind of a norm that you don't sue universities, and that was mentioned before. Now, as universities start becoming patentees, as they start suing commercial entities, as they start going into competition with commercial entities, the commercial entities are turning around and saying to themselves, wait a minute, why am I making it cheap for him to do his research and he's then going to go into competition with me? And so you're starting to see a slight breakdown in the norms. You're starting to see the odd case, and if you actually look at the facts of the cases that have been litigated so far, they're all really odd cases. But as those cases happen, and as the Federal Circuit does take the position that if you want to play the game, play with the big boys, you're going to see a breakdown in that system. Now, I don't agree with that either. I think that universities, even when they do engage in the patenting system, are substantially different from non-commercial actors. I think that although they have a lot of money and therefore they are deep pockets for lawsuits, that money is their endowment. It's supposed to be educating students, not going to pay legal fees and damages in legal actions. So, I think that's different. I think universities' employees are not as fungible as employees at a commercial enterprise. And commercial enterprise, you can make all the employees work on some nifty new project that's about to be launched. In universities, the chemistry department might have invented something terrific, but that doesn't mean the philosophers are going to go to the lab bench. They're going to still sit and write about Kant. So the universities are substantially different. They have a different goal, which is ultimately to educate, to provide certain kinds of public knowledge. So I don't think it's right to actually be equating universities with other commercial actors, such as the view of the courts and certainly the view of people who are engaged in research competitive with the research that universities are doing.
Thank you for the participants. Thank you for your patience. We have a coffee break of 15 minutes.